that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions in the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even
And
need to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this
I
rule.
haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't
nullification.
they be informed of their power?
Because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've
oral
outlined that to
motion
date.
for
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Ocker,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction this court could even give, telling the jury that they are not at liberty to disregard the law. But we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.